The appeal stands dismissed.
Obliged. After the vacation, my friend, I have taken in
From the other side.
my
Yes,
friend is
madam.
here.
Yes, sir. Next.
Pardon.
Yeah, please, your lordship. Item number 16, lordship. Item number 16, 16, lordship. In this case, lordship, I have filed an additional affidavit, lordship, recently. Let it come after vacation, lordship. Recently, I have filed an additional affidavit, lordship. Item number 16.
Yes.
Let it come after vacation, lordship.
With the request of. Yes.
May I please, Your Lordship, I beg to make a mention for item number 13 of the daily list. I request that the matter may be adjourned and be taken up after vacation, Your Lordship.
Sorry.
May it please your lordship. Pray for listing of a writ appeal, my lord. May it be a day after tomorrow on 28th, my lord.
What is the urgency?
My lord, it's a tender matter, my lord. The work order will be issued, my lord. I was a respondent in the writ stage, my lord. The matter went in favor of the writ petitioner, my lord. Now the work order is about to be issued.
Order is of which date?
25th of August, my lord.
25th of August. Then
Yeah.
you are waiting. Then wait. No. Next.
May I please, Your Lordship, I beg to make a mention for item number 13 of the daily list.
Yes.
Lordship would like to make a joint prayer for adjournment of the matter and be taken up after vacation, Your Lordship.
Next.
14 is also similar matter.
Next. Next.
Obliged, Your Lordship.
May I please, your lordship? Lordship, I beg to mention for listing of a writ appeal, my lord, day after tomorrow, my lord. The my lord matter pertains to shifting of a bank, my lord, from my place, my lord. It is the only bank, my lord, which is the Assam Gramin Vikas Bank, my lord. The honorable single judge, my lord, did not consider our interim payer, which I paid for, my lord, stay.
Date of the order of the learned single judge.
My lord, on Friday, my lord, it was.
Friday.
Yes, my lord. My lord, they are proceeding to shifting, my lord.
Permitted. Next. Permitted.
My lord. Obliged, my lord.
May it please your lordship, with the concern of the other side, I beg to mention item number 10 and 11, my lord. Lordship, we are supposed to file affidavit in reply, my lord, in this matter, but the petitioners couldn't come down for swearing, my lord. Due to some difficulties, they are ladies, my lord, residing in remote
The
areas.
request of.
After the vacations, my lord, it may be. Obliged.
There. Sundar, your officer is here or we could.
My officer is there.
Here?
The secretary herself. Secretary herself could not be here, madam. He is deputed one of her.
So what are your instructions? It was only for Mr. Das, only for that limited purpose.
Yes, I know. Last time,
The officer may
Yes.
not have to stay back, therefore.
that's
we
right,
called
my
up.
lord. Right.
I have explained to him to some extent, my lord. If lordship to just tell him what is the exact the references that he have to bring in.
See,
He has to bring.
You are aware about the issue.
Yeah.
Now, the difficulty that we find is this, that how to verify it from factual basis whether a particular school applied when the provincialism was granted. Because for example, in first petition, there are 42 schools in one petition, 43 to be precise. So we want you to verify and tell us, only quasi petitioners, we are not concerned with the whole state. Because Mr. Majmudar once mentioned that we don't have records. That is not the answer. When your own inspector of school has passed an order, some file has to be there. They are also ready to feed you the details within a stipulated time. You check us and prepare a chart and submit it by way of an additional affidavit or a report. But that exercise has to be done by 30th of October, not more than that. For the petitioner, take assistance of as many officers that you want. But it should be, the report should be by the secretary concerned. The officer who had remained present with learned advocate general that day. We want her certificate. She may rely upon the report submitted by the director or any other deputy director, but he has to tell us. We are keeping all these matters on 1st of November. By 30th, that should be filed. Otherwise, we will not wait then. After 1st November, we will not wait. Then we'll presume that it is because the question is proviso. Ultimately, in every matter. In every, whether it is B, C, D, or E, except those two pension matters, this question will arise. So some naturally who will tell us?
I mean,
Yes.
lordship, the respective schools, if they can furnish me, ask the
That
original
we have-
representations,
That we have, the task was there.
lordship,
Mr. UK Nair was not there, therefore we hold up. Otherwise, we were to pass the order on Friday
lordship.
or rather Thursday.
Yes.
Thursday. It was on Thursday. But Mr. Nair had mentioned the earlier day that he is not available on Thursday.
Because if
They will submit whatever they have.
they had at that point of time, whatever representation they file along with their application for
Yes, they will file. There is no
then
difference.
only it will be very easy for us to verify and give the report before this honorable court.
Because to blanket say that no, proviso would apply is also,
The issue is that most of them have not applied also.
therefore,
Lordship.
Learned Advocate
Yes.
General, we understand the purpose of
Lordship.
proviso must be something in mind
Lordship.
of the legislature.
Lordship.
But we have to read it down on fact.
Lordship.
Otherwise, it would carry all of them together.
Yes, under one stroke, and most of them have not done anything at that point of
No,
time.
but Mr. Advocate General, those who have done should not be taken away like that.
Those who have done, they have already got it because this is not the new
you-
time. It
you
was
have-
done in 2011 also,
They have orders from 2005, 2006 onwards.
Lordship.
Your own inspector has passed the order. Therefore, you check up and tell us.
Yes, because with certain our inspectors are also not beyond doubt, Lordship. It is a position is like
Now,
that.
we can't help go into that arena, Mr. Advocate General.
But if they have actually have applied, and they must have got it before that particular cutoff date, 1/1/2006.
No, through
But if
this,
they submit, we'll verify it,
through this exercise, that will also be clear.
Lordship. Yes,
Therefore, this is necessary.
this is perfect, Lordship.
Do we need an order or it will be done?
Lordship passes an order that will bind the officers, Lordship, also to fulfill the target of 30th of October.
We intend to do it.
Yes, Lordship. That
In
will be
fact, we have kept it.
very convenient for us.
We'll count the order properly.
Lordship.
Mr. Das, we,
Yes,
Learned Advocate General may have some difficulty at 2 o'clock.
yes,
But we'll meet at 2 o'clock with the draft order.
right.
So that we want assistance from the government to what level everyone should know. Majmudar is there, he will take care of it. The officer may not remain present. Because it will take some time during, we'll utilize recess time to detect the order. Because it will have to be properly out. The order will be ready at 2 o'clock.
Well,
Next, you,
Highly obliged.
Mr. Kalita, inform Mr. K. Chaudhary's office and well, you can hire.
I'll do that.
Senior advocate, I think, Lordship, B. Das is.
B. Das
Jyoti Das is there.
Das is-
Group B.
I'll
Group B.
intimate.
They will be here at 2 o'clock because the impression is that we take up at 2 o'clock. This was only for the purpose that the officer may not have to sit till 2 o'clock.
I'll,
quickly.
lots.
Next,
Highly obliged.
May I please your lordships. May I please your lordship. Lordship, the petitioner herein assails a mandate of the passport issuing authority to disclose the origin place of birth in the passport of the adopted child who is domestically adopted. Just taking the example, Lordship, if a child is adopted from Rajasthan and the parents are from Assam, the name of the parents will be endorsed as the biological parents, but the place of birth will remain as some place in Rajasthan or in any other place. So the petitioner apprehends that could vitiate the whole process of
no, but
the late.
we were just thinking on a different plank altogether. Suppose adopted child wants to have a birth certificate, what would be the position?
Lordship, pardon.
If an adopted child from Rajasthan,
Yes, Lord.
after some time or during her lifetime, wants a birth certificate, what would happen?
Lordship, the birth certificate and all the records are maintained by the authorities. That is called central. So that record is always accessible if at all that is necessary arises.
No, therefore, the objection by the petitioner is that why that place is to be maintained.
Lordship, the place could be the place of the adoptive parents, Lordship. That is the
No, but
intent
what changes on it?
changes when it says origin place of birth.
See, I'll tell you.
No.
I'm aware about Tara
Yes, Lord.
procedure.
Yes, Lord.
Because I was part of juvenile justice committee, therefore I know.
No.
The states have also respective schemes for adoption.
Lordship.
Now, place of adoption, say, as you are giving the example, Rajasthan,
Child is from Rajasthan and
Rajasthan.
we are from Assam.
and adopted by parents at Assam.
Yes, Lord.
Now, when they adopt,
Yes, Lord.
the birth certificate is always there.
Yes,
So
Lord.
that is the basis. Maybe
Lordship.
name may not be there,
Lord.
but the place where the child is
Born.
born
Yes.
or found. I go a step forward. Say Jaipur at Rajasthan.
Yes, Lord.
Then Jaipur is always mentioned in it.
Lord.
Now you as adoptive parent, maybe you are biological now.
Yes, Lord.
Your name will be there. So and so, his son or daughter or whoever is adopted. So we wanted to know that the only criteria which is provided under the passport rules is that you have to mention the first place of origin.
Village, town, or
Ah.
Lord.
Now you have already those details. What difficulty is there?
But Lordship,
And
that
what changes on this?
only changes that the place could be, the
Hmm.
place of birth could be the similar to the adoptive parents, Lordship, because
It may not be. See, a husband is born at one place, wife may be born at another place. There are instances where reverse case.
Lordship, that could be a possibility, but
We understand everything.
Lordship,
The question is that what is the difficulty with this?
Lordship, another part of the argument the petitioner advances is that, Lordship, in my humble submission, the passport being a travel document which is only be effective being going abroad.
Hmm.
So having the not having the place of origin in the passport as endorsed will not affect in any way the child or the adoptive parents or
No,
any.
but it is two-way.
Lord.
For example, if I apply for passport today here with passport authorities in Assam,
Yes, Lord.
I will have to show my birthplace.
Absolutely, Lord.
Then it
That
has
is
is it your case that if birthplace is X, passport is granted? Why is there passport is not granted?
Not
The
exactly.
purpose of filing this petition, we are get lost totally.
Lordship, only
Apart from the fact that you have changed my surname also in the petition, that is in a lighter way.
that is my apology. That could be my
No
fault.
problem.
Lordship,
Because the petition is for birthplace, so I was little particular in reading the spelling of my spelling also. You have changed my surname, but
Lordship, that will be my.
does it make any difference? I am here only.
Lordship, not in that. Only thing is that adoption enter policy is
The
right around
only
this.
contrary, Mr. Adoption policy till the child is adopted.
Yes.
It is not to be even declared that he is adopted, he or she is adopted by whom.
Lordship, in all essence, adoptive parents become the biological parents. The
We
place,
agree, but what difference does it make to the status of the child?
not the status, Lordship.
Then-
That apprehension is that in future, if at all the child comes to know, there's always likelihood that first thing is that his privacy is that everyone comes to know. Or if at all he comes to know, anyone in the
It
family
is not
comes
a
to know.
question of privacy. Declaring that where you are born is not a privacy.
But on the other side that we praying is, Lord, we're submitting.
Husband and wife may not be belonging to the one native place. They may be.
That is correct, Lordship. But
Their birthplace may be different. Even states may be different.
Lordship, that is correct. And
There are instances where a person is born in a foreign country and now staying in India.
so that could be different.
We don't understand what is the challenge in the petition. With greatest respect,
Lordship,
what difference does it make if Jaipur is shown or Guwahati is shown?
Lordship, the apprehension has been that if the child at all comes to know in future, that is the apprehension that raises.
Maybe.
And if also the practice of declaring the place of
No,
origin.
but you show us from the any other when it is adopted that this is you yourself know that from where he or she is adopted.
Parents will know, Lordship.
Ah,
Only the child growing up will coming to know. That is the apprehension which has been stated in the
But
entire
for
petition.
what which fundamental right of the learned petitioner is infringed.
Not the petitioner, Lordship. The child if growing up coming.
This is PIL.
But
Lord.
the information regarding birth is already registered, already there.
That is kept in a secretive manner, Lordship.
No.
By the
No. Today, if you admit admit her or him to the school, what do? Don't you disclose the birth certificate?
So that I have no instruction. I have not been.
No, you take
Yes,
instructions on,
on
this
that
line.
part, yes.
For example, the child goes to a school or a university.
Which birth certificate would be given? Lord?
Birth
That-
certificate today, if you apply for American visa, you will have to give birth certificate. There, you will not be able to say that I will change the birth date. On the contrary, if this is not provided, your visa will never be granted because your birth of place will never tally with it.
On that, sir, I'll take an instruction Lord, on that.
And moreover, this is ultimately, though you have not mentioned anything in your prayer, we take it that it is mandamus.
Lordship.
You should have approached the authorities first, which is novel idea.
Lordship, fix it after vacations or
Any date of your choice.
after the vacation.
Any date of your choice, sir.
26th, Lordship, the three of them after the.
In week thereafter. 2nd of November or
Yes,
the
Lord.
week begins from first.
Yes,
In
Lord.
that week, please put it. Next. That's the request of Mr. T. J. Sir. Next.
Right.
What happened before the tribunal?
Worship, before the tribunal notice was issued in the matter, the next date has been fixed for today, Lordship. Yeah.
Therefore, I thought you must have gone there first because that also starts at 10:30.
Lordship, yes, we have gone there, Lordship. That order is at page, Lordship.
No. Today I thought that you would go to Kate first.
Lordship, that is in the afternoon session, Lordship. 3 p.m.
Afternoon, then go there. Don't.
Lordship,
Today.
Lordship, we have only approached before this tribunal, before this honorable court, because the coordinate bench of the tribunal, and this is a similarly situated individual, Lordship. He was transferred by the same order from the same post to the same cadre, Lordship. Lordship, in his respect, Lordship, that is at page number 49, Lordship. Relevant is
49 and 50.
Lordship.
50 we have seen. Request the Kate for that. This is an interim order.
Lordship.
Nothing doing.
Lordship, the matter may be remanded with a view to
There is
consider.
no question of remand. We will say that it is pending at large before the tribunal. Go and argue before the tribunal. Nothing doing. Lord Mr. A. Chakravarti.
Chakraborty, Lordship.
Is A. Chakravarti versus B. Chakravarti.
Lordship.
By way of this petition, the Article 226 of the Constitution of India. The petitioner has challenged the order dated 16 16 or which
Lordship, order, that order is of Lordship 3822, Lordship. Lordship, that is at page number 29, Lordship.
29. Has challenged the order dated 308/2022. Whereas the Honorable Court, Honorable Tribunal was pleased to issue notice and also permit the applicant, whereas the petitioner, to file an additional representation before the competent authority. As can be noticed from para 4 of the said order. The other prayers prayed for in this petition are already prayers which are subject matter of OA number 185/2022, which is pending before the court event. The matter is listed today. We do not find any we do not find any reason to interfere with such ad interim order wherein the tribunal has already taken cognizance of the matter. Keeping all the contentions open before the tribunal, the petition is not entertained at this stage. The petitioner is at liberty to
Like that.
take all contentions before the tribunal. This is provincial.
Lordship, this matter may be taken up along with
Yes, we are.
item number 62.
Yes. Next. Yes, Bhattacharya ji was to take instructions. Mr. Bora, this matter was earlier.
Yes, my lord. I have some information, lordship, instruction. Deputy Commissioner said, my lord, this some irregularities in the one of the panchayat is there. The video and my lord.
So you
agreed that-
only to, you go to page 14.
Yes. Yes. The person, my lord, speaking order. Deputy Commissioner person is speaking order informing the Principal Secretary, my lord, Panchayat and Rural Development Department that the officers under his
No,
jurisdiction.
you decide the effort to dispose of the aforesaid pending representation filed by the petitioner
Yes.
within a period of 8 weeks. This is only if
Yes, sir, that was disposed of, Lord.
the petitioner would be at liberty to serve a fresh copy. That is also done by you.
Yes, that has been disposed of, my lord.
Therefore, the only thing is that you have to decide it.
Yes.
9 months have passed instead of 8 weeks.
That delay part is there.
If
Yes.
you turn to page 15,
Yes. Yes, I have seen that.
decide this.
Yes. The speaking order passed on, my lord, 23rd of September.
On this represented.
Yes.
Then inform him.
Yes.
Then the matter ends.
Yes, my lord.
Do you have a copy of the order?
Yes.
Keep it a part of the.
Called Mr. A.M.S. Majumdar
Lord.
for the petitioner and Mr. R.K. Bora, learned senior government advocate Assam. So now it is pending before the principal secretary.
Yes, ma'am.
So we'll direct him to decide it. And Mr. R.K. Bora, the coordinate bench of this court while disposing of PIL 80 of 2021 with a statement and order taken. January 2022. Provided as under page 14 mark 4. Correct. The record further indicates that the petitioner also submitted an additional representation as provided in the order dated 22nd of January 2022 on dated 31st of January 2022, which was received by the concerned department on 1st of February 2022. And as the same was not decided, the present petition, contempt petition, under section 12 of the Contempt Act 1971 is filed by the original petition. Paragraph. Mr. R.K. Bora, on instructions, has produced an order passed by Chief Executive Officer of Church Jilla Parishad Silchar dated 23/9/2022, whereby the Deputy Commissioner Shahar Silchar has passed an order to place the papers before Principal Secretary P&RD Department Government of Assam and Commissioner P&RD Assam for taking necessary action. A copy of the said order is placed on record.
Yeah.
Thus, we find that the order passed by this court is complied with by the Deputy Commissioner in charge of store filter. Cutter. However, we further direct while disposing of this contempt petition, we further direct the concerned authority of the state government to decide the representation as directed by this court in the order dated 21st of January 2022, latest by 31st of January 2023. The petition is disposed of accordingly. You put this on a record,
Yes, sir. It is a part of record.
to come by, give it back.
Obliged. Obliged.
Next. Photocopy, you give it back to him, he will give you the photocopy. Government has to get it done. Next. It is provincial.
Lord, I availed a loan from PNB Bank Lordship and account become NPA. Then the bank had filed the OA, recovery certificate was issued. But thereafter property was put to public auction twice, no bidders turned up. Then in the meantime, I filed, a investor has come, Lordship, to invest in the industry. So Lordship, I filed an OTS proposal before the bank on 21st of this month. And the bank replied in the letter that you deposit 15% of the NPA. So accordingly, I have deposited 15 lakhs on 22nd of this month, Lordship. So already, Lordship, I am apprehending that the bank may take the position of the industry, Lordship. My limited, no, Lordship.
We can protect you like this indirect.
No, no,
or
Lordship,
direct.
only my limited that till disposal of my
Nothing.
OTS, Lordship. courtship
You told me that OTS is a right of the borrower.
Right, this is a MSME unit, Lordship.
Maybe any unit.
RBI, yes, yes, that is there. I have.
This
And-
indirect method of, if you read today's newspaper, you will find that this bank maximum NPA is there in India. This very bank.
No,
is
Lordship,
there in today's
there
newspaper.
is a RBI policy by the state, RBI policy in respect of MSME unit, Lordship.
Therefore, we are not coming in your way, but these are not inherent rights. You forget fundamental right. It is not even a legal right.
Lordship, I have, Lordship, may please to consider bank is ready to settle on ATS basis. That's why bank had.
Therefore,
direct-
we'll say that you may approach the bank and bank will consider. That much we can say.
Lordship, only limited prayer that bank, I have, they are good, they are ready to settle, Lordship.
For temporary
Industry-
injunction is not permitted and
A small scale industry will be saved, Lordship.
Look, the OTS proposal has already been rejected on 23/9. That has been communicated. Madam, if I may pass over rejection.
When?
23/9 by mail, 6:57 PM on the very same day. In fact, madam, they had also gone to the DRT filing a securitization application. Madam, that has also been rejected. I've also taken the liberty to
Lordship,
annex that order. That order, my lords, of the DRT is at page 5. 4.
They inform you to collect the check of 15 lakhs of it.
Lordship, in case of MSME loan industry, there is RBI guidelines, Lordship, page 17, which specifically says that the OTS should be provided.
Therefore, we are ready to say that you, again, if you want to approach the bank, you approach the bank. We will not interfere in this recovery proceeding.
Okay, Lordship, we will approach.
Told Mr. S.P. Roy for the petitioner and Mr. Ganguly for Punjab National Bank to respond. Here is by way of this petition under Article 226. For the following reading. Mr. Ganguly, learned counsel appearing for the respondent bank has submitted that the proposal for OTS has been rejected by the bank with a communication date of 23rd of September 2022, and the same has been already communicated to.
No, we have not received it.
We don't say that it is received, right? It has been communicated to the Suresh Agrawal being director of the petitioner company. Mr. Roy, however, submits that the same has not been, we see that it may be so. The fact remains that the OTS proposal has been already stated and no interference is called for. The trade force cannot be considered in view of the fact that, as informed by Mr. Ganguly, when the application filed, the section 17 of the Surface Act has been dismissed by the recovery tribunal. Therefore, we do not find any reason to interfere with. We do not find any reason to entertain this appeal. Entertain this petition. The Roy, however, submits that as per the directives for by the government and the petitioner industry being small scale
MSME.
MSME.
Yeah.
MSME industry. The bank has to consider the same. When considering the guidelines which are relied upon, it is for the bank to take a decision. The petitioner is at liberty to approach the bank. Again, if the rules so far, the petition is otherwise not entertained or carried, then dismiss. Next.
Oblige.
Lordship, in this case, Lordship, I was directed to produce the list. Lordship, I got the list, Lordship. I wanted to file an affidavit. I filed some discrepancies. Though they have given me an affidavit, it's in green, Lordship. I have to change it. If your Lordship will take it up on Friday, by then I can file it, Lordship.
After Puja, at the request of Deputy Solicitor General,
After Puja.
to file a fit further affidavit. Next. Here also affidavit is- Here two appears for Assam government.
Praise your Lordship. As per the last order, the respondent is directed to file an
Affidavit.
affidavit.
Here two appears for the government.
Council.
Council matter. I am appealing for autonomous council matter. Some chance may be granted to file the affidavit. We have not filed the affidavit.
At the request of trying to comply with the order dated 19/5/2022 as the last chance is given up to
Your Lordship,
26th of November. Next,
applies to Lord.
26th of October, I'm sorry. Next,
Applies to Lord.
May I please, your Lordship. My Lord, the petitioners are the casual workers, my Lord. Their claim are rejected only on the ground that, my Lord, in absence of, my Lord, the service role. And only on the basis of, my Lord, long service, their service cannot be claimed under the Assam Service Pension Rule, my Lord. My Lord, kindly see page, my Lord, page 82, my Lord, paragraph 7, my Lord. My Lord, the findings of the, my Lord, Honorable Single Judge, my Lord.
20 years of service.
My Lord, 82, my Lord.
Who is for the government?
See, Lordship. 4/6.
Last time Mr. Gogoi appeared for the forest department.
My Lord, the petitioner had rendered, my Lord, almost most of them, my Lord, had more than 30 years, my Lord. Only few, my Lord, 3%, my Lord, more than 27 years. I have given in, my Lord, para 2, my Lord, page, my Lord, page, my Lord, 7, my Lord, the, my Lord, service detail, my Lord.
Mr. R.K. Bora is there? You also is there. Last time he had appeared, therefore you make your things clear. File affidavit.
Lordship, will meet me after Lordship. After Puja.
Next.
Highly oblige, your Lordship.
Lordship, in this case, Lordship, I am written by Senior Counsel N.K. Chaudhary. Due to some personal difficulty, my lord, he has to leave very urgently. My lord, some personal problem. Let it be on day after tomorrow.
How no there? Next. After next. No, sitting.
Well,
Next. Yes, Mr. Chaudhary.
May his lordship kindly pass over for time being. Senior on legs.
Pass over. Will. Yes, Mr. Nath.
The IO has got the prosecution sanction. My lord. Now, SP has instructed the IO, my lord, to complete the investigation as soon as possible. They will immediately complete the investigation. My lord. I have the.
When will you do it? Tell us.
The lordship may keep it after the reopening. My lord. In the meantime, they will complete it. I'll submit the report.
26th of October.
26th of October. Lordship.
Mr. Nath.
My lord.
Mr. D. Nath. Government Council states on instructions that the investigative is being supervised by Superintendent of Police. And based on record, communication dated 23rd of September 2022, which is taken on record. Mr. Nath further submits that the investigation shall be carried out and the report shall be submitted by the next date of hearing. At the request of Mr. D. Nath, written to 9th of November. By that time, see that we are granting you more than a month for this.
We'll do this.
Be over.
No problem.
Next one. Here also report was.
May please, your lordship. Lordship, on the last occasion, lordship wanted me to see the charge sheet and my lord submit on whether the investigation was properly done or not. Lord, I have received a copy of the charge sheet, but it not in entirety. Lord, the statement of the witnesses are not part of the charge sheet. The copy given to me. That is one aspect of the matter. And whatever is available with me after going through this, my lord, I could find that there were 40 witnesses. And the IO relied upon only statement of 5 witnesses while preparing the charge sheet. There was no test period. And basing on that, the learned court session judge came to the conclusion that there was only circumstantial evidence, no eyewitness. Lord, it is an incident wherein the lockup was broken by the Milord accused person, alleged accused person. Lord, they were dragged from the lockup, Milord beaten up, and thereafter they were burned in the marketplace. How can there be no eyewitness? 40 witnesses were there, only 5 witnesses were relied on.
Mr. Goswami, firstly provide all the papers to the amicus.
Yes.
Do it before we close for the puja holiday. What Mr. H.K. Das? Amicus duty and advocate for the High Court. Mr. Goswami, P. Goswami, Lord Additional Advocate General, Arunachal Pradesh, assisted by K. Chandran, for the state of Arunachal Pradesh, Mr. R.K.T. Chaudhary, Learned Deputy Solicitor General of India, appears for the phone number 5. Here, H.K. Das, the counsel appearing for the Saudi High Court, states that all papers have not been given and hence it is not possible for him to examine the B. Also, the petitioner advocate Arunachal Pradesh states that all other papers shall be handed over to the judge. Latest by 28th of September 2020. 10 to 10th of November. Next. DPO. Yes, service is awaited.
May I please, Lordship, Lordship, matter become infructuous.
Infructuous.
Yes, Lordship.
Next. Yes, Mr. Goswami.
This is with regard to victim compensation, my lord.
Yes, Mr. Goswami, what are your instructions?
My friend, Miss Pulu, Bulia Pulu, she is to provide, she is appearing for the institute in where the victim girl is being kept, and they are following up on that compensation.
See, that is to be
She appeared
finalized.
on the last occasion.
Last occasion she was there.
Yes, she was there.
We have permitted her access also this time. But he is not responding to the video. Mr. Goswami, the Salsa in Arunachal Pradesh does not have any funds for this. So this has to be sanctioned by the state government. I am told a proposal has already been made by Salsa, but government has not sanctioned yet. It has to be sanctioned immediately.
Yes, sir.
This is victim compensation.
My lord, that has to be given. We have also, my lord, a scheme, my lord, of the state. So it can be taken up.
To tell us by Friday that when are you going to pay the compensation? There is no need of any formal application.
My lord, so it will be better, my lord, if we hear, my lord, Miss Pulu, my lord, before that, my lord, because some developments are
He has
taken.
not to do anything. He has not to do anything. He is not responding. We have already permitted her access.
My lord.
It is the government who has to
pay the compensation.
make the payment. Your officers have to sanction it, which they are not.
We'll take it up.
Tell us on Friday, so that otherwise we will do it within 1
my
week. At the request of Mr. P. Goswami. And additional advocate in the last Arunachal Pradesh, April to 30th of September. Next.
Much obliged.
Yes, who appears for the petitioner?
Lordship, I am appearing on behalf of the petitioner.
Yes.
I am appearing for response number 2 and 4. We have complied with the order of this honorable court, and the tender process has already been initiated, and it is at the final stage of it. Only work order is to be. So, regarding the matter, back to the matter, your lordship, the petitioner has challenged an order whereby this we the respondent corporation has permitted an individual to run a tourist close temporarily, your lordship, because of two reasons. One, because of the cabinet decision of Government of Assam, and because of the situation emanated from the outbreak of the COVID pandemic. There was no one, and the bidding process could not be completed, and that is why it was given to an individual. They have challenged it. Our initial objection in the PIL was that they cannot do that by way of PIL because contextual matters cannot be by way of PIL, they cannot bring it before your lordship. But thereafter, since your lordship has, by an order of this honorable court, permitted us to do the tender process, we have done the tender process, your lordship. My humble submission will be that whatever relief they have sought for, they have already got, your lordship.
You produce,
Still their property.
you produce the work order on record, will dispose of it.
We have already, by way of an affidavit on 22/8/2022. Your lordship may kindly peruse the affidavit dated 22/8/2022.
अरे भैया वो affidavit तो हमने देखी. There is nothing in that affidavit except first extension and second extension.
Yes, the tender.
Page 110. I have read that, therefore I am telling.
Yes, your lordship.
The question is, you produce the work order on so that will end the possession given to the successful bidder.
But my lord, we are on the larger issue. The fraud committed by the department is.
Let him first do it.
But the fraud they have committed.
First do it, sir. Let them redo it.
They are doing it since 6 months, my lord. They're not.
Then we will admit for hearing it will be 6 years. Let them first give it to somebody else and give possession. Then we'll see. Your larger issues are there always. You are also in the same business.
No, my lord.
Next. Next. When will you do it?
2 weeks time, 1 week time may be given. 2 weeks time. After vacation, your lordship.
20.
28th of October, your lordship.
20th October. And we want the possession, letter of possession being handed over to the successful bidder. Let us be very clear.
Lordship, I'll obtain inspection and I'll also ask them to.
So you bring it on record.
You
I'll
bring
bring
it
it
on record.
on record, definitely. By one of the
Here there was a request for video. Last time I think somebody had appeared to this. This is 90. Somebody has it is. Yes, Mr. P. Nayak is there. Passport. P. Nayak was to file affidavit.
Lordship, item 96, petitioner had informed us for an adjournment.
You were to file affidavit.
That, your lordship, I don't have an
For Mr. Nayak. Last time we have recorded that you have to file anyway. Is the same person. Okay. We received a request on mail. Or next.
Please, my lord, in this matter, we were to file an affidavit, which ought to have been filed on Friday. There was some delay as far as the officer is concerned. It's being filed today. And it contains valuable material for deciding this matter. Lordship may give any date on which you can find. Meanwhile, I was
Affidavit shall be filed today.
Wait.
Which date would be convenient? Which date do you want?
next month, that of after tomorrow, in October, maybe towards the end of October. Okay. I don't know, could it be had maybe on 6th or 5th?
Next week I may be in an outlying phase.
Or after 11th, maybe.
After 11.
After 11th.
14.
13th. if it's
14.
permit.
13th would be holiday.
14.
14. Next.
I'm available.
Yes, 99.
Yeah, plead your lordship. Lordship, we are seeking some time in this case, lordship, as we want to submit some documents regarding the land and property. Because as of now, the respondent does not have any property. So we are seeking some time so that we can submit the document.
The request of we are to the next. The Pathak appeared last time.
In this case, also the excise department is supposed to file affidavit.
We are also in search of excise department. Pass it over. Next.
May it please the lordship. My lord, in the writ petition, my lord, we have challenged the virus of the rules, my lord, which regulate the admission of students to MBBS course. My lord, similar provision was interfered by this honorable court, and in spite of that, my lord, same very provision has been inserted. If I may be permitted, my lord, if your lordship should kindly take the PIL file, my lord. Page number 73, my lord.
This is Supreme Court order.
No, my lord, page 73 is the honorable court's order. If your lordship should kindly come to page 64.
Our paper book, it is Honorable Supreme Court.
No, I'll come to that, my lord. First, my lord, may kindly come to page 64. This was the earlier rule which has been struck down, my lord. 5.
No, what a pagination would not, doesn't seem to tally, but you can.
I'm referring to that PIL, my lord, PIL 6 of 2021. Item number,
no, that we.
Oh.
You are referring to order of 49.
PIL 6 of 2021. Acha, renumbered as, yes, PL 44 of 20. I'm sorry, my lord. Yes. PL 44, yes.
44 is the matter that you are arguing, Mr. Chudri.
Yes.
Here, you are referring to which order because our pagination is.
Okay, I'm sorry, my lord. I am referring to order dated. Order dated, my lord, 22/2/19, passed by division bench of this honorable.
In our paper book, it starts at page 60.
Yes, it's even 60 here also. Here also, my lord.
It is PIL.
Yes. 60 years, my lord. My lord will kindly come to page 64.
Yes.
This is the rule, my lord, which was assailed in the earlier round of litigation. 5.1. All applicants shall be classified into 3 categories for the purpose of allotment of seat. Children of permanent resident of state of Mizoram as category 1. Children of other permanent residents of state of Mizoram as category 2. Children of central and other state government employees not permanently serving in Mizoram as category 3. My lord, we fell under category B. Now, this was a challenge, my lord. My lord will kindly come to page 71, the operative portion of the order of the division bench, para 19. In view of the above discussion, we are of the opinion that the impugned rule placing children of non-geoethnic people of the state of Mizoram in category 2 cannot be sustained. It is further observed that they have to be placed along with geo-ethnic people of the state of Mizoram. Correspondingly, liberty is granted to the state of Mizoram to refix the percentage of seats to be reserved for categories of candidates as finding mentioned in Rule 5. Having regard to the facts that more than 2 years had elapsed, we do not consider it appropriate to interfere with the admission taken under the impugned rule. Therefore, what the state of Mizoram did, my lord, under the constitutional scheme, state has no power to, particularize or categorize any person as ST or SC, my lord. It is the prerogative of the president and the parliament under the scheme of the constitution. Now, what they have done, my lord, they have the scheduled tribe, according to them, of geo-ethnic, they are the Mizo. Rest are in another category. So that classification was held to be bad. Now, my lord, same thing has been done again by the amendment. That's why we are before your lordship. My lord will kindly come to Rule 45, page 45. They presently with the rule which is under consideration. 31st of May 2001, which were challenged in the PIL, my lord. Pursuant to the decision of the Council of Ministers, which was obtained by means of circulation and conveyed by Political and Cabinet Department, white dated so and so, and in the interest of public service, Governor of Mizoram is pleased to make the following rules, further to amend the Mizoram selection of candidate for higher educational courses, Rule 2016 as follows. Now, please come to 2, my lord, amendment in Rule 5. In Rule 5 of the Mizoram selection of candidates for higher technical courses, Rule 2016, hereinafter referred to as the rules. Sub-rule 1 shall be substituted by the following, namely, applicants who shall be classified as follows for the purpose of allotment of seats. Open category A, that is, children of local permanent scheduled type ST Mizo, a resident in the state of Mizoram as category 1, the same thing which they did earlier. Children of other non-local permanent scheduled type ST, non-Mizo resident of the state of Assam, a state of Mizoram as category 2. So I'll respectfully submit, my lord, this honorable court has already said such a classification is not tenable. And the matter was taken to Supreme Court. Supreme Court dismissed the SLP. Then a review was filed in Supreme Court. Review was also dismissed. Now again they have done, my lord. And they have added one more thing, my lord. Now, please come to next page. They are giving only 1% seat to the open category. That too, they are putting all this. Obstacles, my lord. The term open category shall include candidates belonging to any of the scheduled tribe of Mizoram who have been permanently residing in the state of Mizoram, provided that to be eligible for consideration under open category, the candidates should have passed class 11 and 12 from any schools within the Mizoram state recognized by the government of Mizoram. The term Mizo shall mean those who are geoethnic indigenous people of the state of Mizoram and have been residing permanently in the state, and term non-Mizo shall mean non-geoethnic scheduled tribe ST people of the state of Mizoram and have been residing permanently in the state. Sub-rule 2 shall be substituted by the following, namely, now kindly see, my lord, percentage of seats allocation shall be 4% for open category, 93% for category 1, and 1% for category 2, 1% for category 3, and 1% for category 4. If 1% is less than 1, then in such case, it will be rounded up as 1 seat. Provided that to be eligible for consideration under category 2 and 3, the candidates should have passed the class 11 and 12 from any school within the Mizoram state recognized by the government of Mizoram. My lord, my humble submission is, my lord, this classification is prima facie bad because state of Mizoram has no authority to describe somebody as a local scheduled tribe and somebody as other than local scheduled tribe. If it has to be done, it has to be done by the parliament or the president. Yeah.
is the case of the state that a particular caste is declared to be scheduled caste by the state and by notification?
Yes, that is what they have done, my lord. Though they do not say directly, indirectly, that is what they are doing. My lord, we kindly see this. We have given this.
In a particular state, get from caste may be scheduled caste. In another state, it may not.
That's the thing. That's okay. No, my lord, we are Sakmas. We are already scheduled tribe in the state of Mizoram in terms of that 1950 order.
I'm referring to that.
Yes, we are already.
So what is this difference of again?
Actually, now they are trying to make a distinction between, actually, my lord, these Sakma people, they originally belong to Sitagang Hill tract of my lord Bangladesh. But they didn't East Pakistan. They came over, my lord, post 1947, and many came after 1971 because of the internal strife in that country. Now some of them have come, some were already there. But then Chakmas are treated to be a scheduled tribe under the Scheduled Tribe Order 1950 for the state of Mizoram. Now, where is the scope for the state to make a rule for regulating admission to MBBS course, rather than making a classification? That power does not lie with the state government. If at all that power is there, it is of the parliament and the president. This one. Schedule caste this one. And the schedule caste this one. Now, schedule caste order list one.
Mr. Das, yes, no affidavit, it has come from state of Mizoram.
We have filed. My lord, this is today, the matter has not come for hearing. Today the matter has come for IA. Why I'm saying, my lord, their whole case, we made a rule. We made a rule saying all non-Mizo ST. In Mizoram, all are ST. Mizoram, all are ST is classified non-Mizo ST. There is a rule which has been made. Whoever has studied outside, like class 11, 12, has not studied in Mizoram, my lord, studied outside, they will not get the preference. Non-Mizo ST. And there, when you form the NEET form, my lord, I will show an IA, you have to select the state of preference. So in this case, my learned friends client, all because they studied from outside, there is a judgment which has been held also, which goes against them. They 11 and 12, my lord, they are barred. If they have studied from Mizoram, absolutely no problem. They studied from outside. Kindly see the IA, my lord. Kindly see the IA. What is a prayer day? That is the whole case, their case. Kindly see, my lord, the IA. IA in, my lord, PL 44 of 2022. This IA has come. Kindly see.
My lord, I have not completed my case.
Your lordship will ask me
We
that.
are asking him because without affidavit we can't go ahead.
No, my lord, but the problem is, my lord, on 30th, my lord, the last date of counseling.
This is waiting since 21, Mr.
No, no, my lord, no, I am for this current year.
No, I am also for the current year.
Yeah.
If we have found from the record every time in September, something is being argued.
No, no, my lord.
I will show you the record.
No, my lord, last year, in spite of the judgment, we are not admitted.
No,
We have filed contempt is also there.
No, contempt is, my lord, we have that has been
Anyway, let
taken
my
care.
learned friend conclude, my lord, I'll make my
My lord,
submission.
kindly see para 7 of their IA.
Mr. Das, you file reply to this. We can't handle such a matter without.
No, my
that's
lord,
why.
no,
I'm
what I
just saying. No, I'm just saying. What they want provisionally, my lord, their scorecards should be accepted and counseling and get and provisional admitted, which is not possible because they are not entitled under the rules.
Therefore, you file an affidavit.
Yes.
No, my lord will kindly bear with me for 2 minutes, my lord. Now, we have filed this IA because last year, in spite of there being a judgment, my lord, we were not admitted. This year also, they have no intention to admit us.
Therefore,
now, my lord, earlier, the last date was 15/9. That's why we filed the IA. Then, my lord, then the last occasion, my lord, we came to know that this last date has been extended to 39, coming 30th, my lord. That's why we have some urgency. That's why
we'll take care of your
apply. No, all that we are saying is, my lord, either, my lord, 5 seats should be kept vacant, or we should be given provisional admission subject to the outcome of
No,
the
that
case.
cannot be, my lord, because all other local, that non-lease of ethnic also, they will be affected, my lord. Deprived.
Be only on IA.
IA, today is IA, my lord.
My lord,
Today
at
we are
least
on
some
IA.
protection so that in the event I succeed, my lord.
You listen to our order.
My lord, my lord.
Write the appearance of interest. By this IA, the trade for is in relation to trade for is for provisional participation in the council. Mr. Das, learned counsel appearing, learned advocate general states that no provisional admission can be granted. As against this, Mr. Chaudhary states that the 30th September is the last date for counseling.
Counseling, my lord.
For submitting scorecard, my lord, my lord. Scorecard, submitting scorecard only. Counseling will come later on.
No, otherwise, if you can't submit, then
They
you will
cannot
not
submit,
consider.
by the way, there is a judgment of Supreme Court, I'll show it, my lord.
Considering the statements made in the IA, it is essential for, it would be necessary for the respondent state to file affidavit in all the, any admission shall be subject to further of. Next.
Deeply.
Subject to further my lord, my lord, may I make one submission, my lord? My lord, my only submission is, since my learned friend has said that the date for counseling is yet to be announced, let them accept our application only. Further consideration will depend upon the outcome of the case. No, otherwise, my lord.
Once it's accepted, my lord, that cannot be done. I can show it, my lord. Why it cannot
No,
be accepted?
no, my lord,
Yes.
my lord will kindly bear with me, my lord. I do not know what judgment my learned friend is
No,
referring
raise
to.
it.
Let me submit,
Ah,
why?
you submit.
Mr. Chaudhary and Mr. Das.
No, my lord, when I'm submitting, why should you jump over us, my lord? No, my lord, my submission is, prima facie, this is a rule which is absolutely arbitrary, my lord. It cannot withstand.
We'll examine that.
No,
That is
what
why.
I'm saying is, my lord, tomorrow, even if your lordship is inclined to allow the petition, if we are not submit the application, my lord, then, my lord, our purpose will be frustrated. So all that I'm saying is, my lord, let them accept our application, only that much.
Which date now?
My lord.
Which date?
My lord, immediately on reopening on 20, my lord.
Select the date.
19, my lord.
19 would be
20, my lord, or 21.
2021, no problem.
My lord.
But you want your affidavit before puja.
Yes, yes.
Before puja.
Yes, yes.
Affidavit before puja.
And my lord, because in such matters, we should not expect that again a prayer for adjournment will be made on that
What my
day.
learned friend is saying, what adjournment, my lord? I have not asked for any. Now he cannot anticipate that I'll take adjournment in this case.
Going by the way government behaves.
Yes.
We have
No,
made
no,
that
you are, I see no.
Yes, sir.
May I please, Lordship?
Now here you have the death certificate of the person.
My lord, in the year 1983, my lord, the father of the appellant was
This is why we told you that we
but
want death
at that time there was no death certificate, my lord. Before 90, my lord, there was no death certificate.
certificate has to be there. Mr. This is a matter with little difference.
Little different. The person died. That's why
Person
they are
died.
doing-
Now he died how?
How? Nothing to show, my lord.
In the Assam movement, my lord.
Nothing to
So
show.
you show us that he died in Assam movement.
Only his
No,
name is
Assam
enlisted
India,
in the
my
ballot.
Regarding this, my lord, after of the all Assam students in my lord, the
You
certificate.
read para 9 of the judgment of the learned single.
My lord,
Please read that. There are 8 onwards. There are no medical certificates in the writ petition.
my lord.
Whenever
Nothing,
this
yes.
court to come to a finding that finding as to the injury suffered by father of the petitioner and as to whether said person's physical disability led to total physical disablement in terms of rule 2F of the 99 rule. Now, without any evidence, we can't grant you any ex gratia that to in our jurisdiction. There has to be proper documentation by you. Sir Bora, one thing can be which was passing in our mind, we may disclose. We may not entertain this appeal, but we may give him a liberty to apply again with proper documents.
Yes, before the appropriate authority.
They are poor people, they don't know what is what.
Yes, yes.
They don't know the law of the land also. These people must be helping them. Doesn't seem to be a totally hopeless case as we had other four, which we have already dismissed. We are not entertaining this because in absence of any material we can't. But at the same time, you also the petitioner should not be at loss.
Yes, that is the authority will verify.
Really, his father has then rule 2F will cover his case in his favor. Then he would be entitled to the benefit of the rule. Nobody has examined.
If he really is a victim of that.
Nobody has examined. With great respect, even learned single judge had no occasion to examine because no material has been produced.
Before the honorable single
Sir
judge.
Islam, this is the only way out.
Well,
We may give you one charge, you have to go with it proper documentation. We are in a world of evidence. It may not be okay, but some evidence has to be there. We don't refer to evidence act for that, but some material on record. How did he die? His death certificate has to be there. You say he died in 83. It may correlate with the date of Assam movement. Maybe. But how he has expired? A person who might have died at home because of some heart attack, you want a certificate of injury. Both things can go together. Therefore, we segregated this matter. What do you say, Mr. Islam?
That is why some all Assam student union issued the certificate.
That certificate cannot
There
be
is-
just relied upon with great respect.
But there is no death certificate.
There has to be a death
There
certificate.
all Assam student union issued the certificate by their registration number is
That
there.
certificate is only for the participation, sir. How did he die? Because of any injury, some medical certificate?
The gunfire, my lord.
Huh?
In the year 1983, my lord, he died in gunfire.
Where is that certificate?
But that is regarding that, my lord, there is no.
Where is the certificate?
And the certificate is not available.
Then,
That certificate at that time there is no.
so we have to accept your oral version and grant you benefit. It amounts to that, which is not permissible.
If he is died in a gunshot, my lord, then definitely there would have been a postmortem report also, my lord.
Yes. Then he would have received compensation.
Yes,
from that.
compensation.
Mr. Islam, in absence of any material on record, we can't help you. But in this case, we may permit you to file a fresh application. File a fresh application. Heard Mr. R. Islam. B. Islam.
B. Islam.
For the appellant and Mr. R. K. Boral and Signal Senior Government Advocate Assam for the response by way of feeling aggrieved and dissatisfied by the judgment and order dated 8/6/2022 passed by learned single judge in petition civil number 31. This is for 3167, isn't it? It's a common order. Three one six seven. 2022. The original petitioner has challenged the same by way of this appeal. In the case of the appellant, it is father died in the year 1983. Father late Sri Polindra Majmudar died in 1983. However, no death certificate or any other material to seek benefit of Rule 2A of so and so rules have been put on record by the appellant. Mr. P. Islam, learned counsel appearing for the appellant, has even expressed his inability to produce any such document or evidence before this court in this appeal. On the contrary, the record shows that the appellant himself was 39 years old. He was born only in the year 1983. As noted by the learned single judge, there is even ambiguity as far as the actual date of birth of the petitioner is concerned. In absence of any material on record to show whether the father of the appellant was the victim of Assam movement and whether he expired because of any injury sustained in such a movement. Straightway, on verbal version, cannot be said that the appellant is an affected candidate under section 2A of the 1999 rules. Thus, the appeal is without any material on record. It is therefore not entertained as dismissed. However, should be open for the appellant to apply again with appropriate documents such as injury certificate of his father, medical certificate such injuries sustained and the death certificate before the competent authority, and if the same is filed, competent authority shall consider the same in accordance with law without in any manner being influenced by the fact that his earlier application has already been rejected. However, it is clarified that in absence of any material, the applicant shall not be permitted to file a fresh application. With this observation, the appeal is dismissed. The appeal is then dismissed with the aforesaid liberty. So next.
The service on the respondent number 1 is not complete.
We have just entered appearance on behalf of the respondent number 1 matter. And let the matter be listed after the vacation and copy will be provided. Yes.
Heard Mr. P. Desai. What is your name, sir?
A.K. Burwa, my lord.
A.K. Burwa, take the instructions to appear on behalf of respondent number 1. It takes time. Please take your space. 11th of November, 18th relief to continue. Next.
My lord, I have a further prayer for stay of the direction D in the judgment.
We have already
Lordship has stated the paragraph 24. That is with regard to payment of the cost that we have already complied with. Basically, the REIT appeal have been filed. REIT appeal have been filed only with the setting aside of the so-called notice that was issued by the respondent.
As far as further relief is concerned, we will have to hear it. Next. Next.
Here, madam, I am praying for some time, madam.
the request of
Well,
Your lordship, there is a delay of only 1 day, lordship, in filing a writ appeal, lordship. Kindly this delay may be condoned, lordship.
what is your name?
B.U. Lafta.
What the applicant that is Bhattacharya for respondent for 1 to 5. Considering the fact that there is delay of only 1 day, we do not find it necessary to notice to the prior report. And report number 6, fact of this case, delay of 1 day is okay. The main matter is listed on 19th of October. 19th of October, first day of the reopen. Next. Hold up. You don't get that there, hold up. Any other seat? Three seconds. Yes, Mr. Chaudhary.
Yes.
So we follow the division bench judgment.
Only thing, lordship, would you like to consider the contract?
What are the prayers? Make sure. Now inquiry is already made.
Yes, your lordship.
So your prayer. Now read your prayer.
Yes, your lordship. The inquiry is already made, your lordship.
Let us read your prayer.
Yes, your lordship.
What survives from the petition?
In the premises posted, it is most respectfully paid that your lordship, with this petition, issue a rule call for the records and or may be pleased to issue it in the nature of mandamus, letting the respondent authorities to immediately entrust an inquiry into the unnatural death of the deceased Pranjal Nazari, Raju Nazari, Roslin Nazari, Divanan Iskari, and Rajiv Chamtamari to an impartial and neutral agency and to initiate a judicial and or to initiate a judicial inquiry to the incident and or escalate the pace of the inquiry of the apostate matter if there is any and or direct the arrest of murderers, more particular respondent number 3, 4, 5, 7, and 8 involved in the incident and or any other order direction to give full and complete relief to the petitioner and or on perusal of the records and after hearing the parties may be pleased to make the rule absolute. And that was my prayer. The inquiry is made, your lordship, and as for the after the inquiry, it is found that they died in the custody. Your lordship may kindly peruse page 43. Your lordship is aware. So may I pray, your lordship, as per the direction of the division bench, your lordship is aware. It will be disposed of, your lordship. The case will be disposed of.
That is why we have kept it there. Now you have no objection as far as because FIR is also lodged. What has happened to that FIR?
I am not aware of it, your
Charge
lordship.
sheet is filed.
So, it, lordship,
Yes,
Yes, Mr. Gora. Page number 43, 44. Compensation will have to be paid by the central government. No, what has happened to the FIR? We will have to mention that after investigation, what has happened? Counsel, are you aware about what has happened to the FIR?
No, Your Lordship, I'm not aware.
Well,
I'm just searching, Your Lordship. Maybe there's a method issue.
huh? At 2 o'clock. We'll take up at 2 o'clock.
Yes, sir.
May I please your lordship? Lordship, my affidavit is ready, but department has to sign it. I have already informed him he will be coming soon. Also kindly taken it up after puja vacation. Lordship.
It's the request of the excise paper. Section 2, 1st of November. 1st of November.
Lordship.
You can pass it on. The draft order I already prepared. Both of you can have a look at.
Yes.
Huh? Yes, Mr. Das.
Yes.
Oh. It would be 5%, huh?
No, you already.
Yeah.
Oh. English petition. Acha. English petition. What do you want to?
Okay, my lord. But this will cover only one case, but there are some cases where, my lord, some teachers have been appointed as tutors.
No, no, that is on a different point.
As far as this matter is concerned, fine.
Is it confined to group A?
Yes.
Or
Basically group A.
No, it will get it done for up to E.
Oh.
Up to E. So
Because that is the first criteria.
Therefore, because that criteria is common.
Common to all.
Yes.
Except those 2 matters of pension. Where now the view taken is that if the rules provide, you are aware about the latest law of the
Recent, yes.
Supreme Court. That if the rules provide that it is to be continued, then any type of service has to be clubbed together. Then they may get benefit. That's the
correct, man.
We are eloquent, more eloquent than necessary.
All the cases, man, proviso is there, provided that that's the main issue. Whole issue.
That is why this
Yes,
exercise.
yes, right, right.
So far as the group B is concerned, my lord, there is no dispute so far as regard the recognition granted before 2005.
That we will hear you at length. Therefore, we have kept such a timetable that it may be over within my.
No, Lordship basically wants to know whether we can overcome the first hurdle.
Because you will get the copy.
My lord.
So that you can communicate to it. And we are again making it clear will rely upon the officer who will remain present day before yesterday.
Yes, yes, madam.
Vijaya Chaudhary.
We don't know the name, we don't want to have any name.
I know her
Yes.
because once she was my client. She was
He is the secretary.
secretary.
He was formerly director as I was.
Yes.
Yes.
You will get the order by.
My,
We forgot to tell all of you in the morning at
No, that's okay.
no,
10:30 that from today we are live on YouTube.
Yes, I came to, there is a notice which has given.
Notice is there, but
Yes, notice and live streaming is going on.
in 3 codes.
Yes.
1, 2, and
1,
6.
2, and 6.
120. Because the bandwidth is little to be reformatted. Then it will be before all the codes.
Clear.
I think Supreme Court has also started from today.
From tomorrow.
Tomorrow, 27.
It will be included. And who is the government counsel? You are the government counsel.
I'm standing counsel, education department.
Therefore, you will have to take the numbers from court master
Yes, madam.
because they are scattered. Some new today one more new matter has been added.
Yes, yes, madam.
So please take care. It may not happen that one matter may be left out. Follow.
Oblalo.
Mr. Chaudhary, I think that the judgment which you were showing it to us or at the earlier stage is now reported in the report.
Yes, yes. So far as Lordship was on the police report, Lordship, the state government had filed an affidavit. Any on record that was filed on 25th of July. Where the police case ended in a FI.
Therefore, I was inviting attention of
The learned AG Lordship.
was not learned counsel that his prayer was for inquiry. If he is satisfied with the inquiry, we may not go further into it and deep into it. Because turn to page 163. There are 47. Who is the eyewitness? His statement is there. It is also stated by so and so that during the inquiry before magistrate, it did not state anything. On the other hand, it was stated by the army side that he clearly stated that the executive magistrate that the 5 boys took shelter in his home and they were the members of so and so. So as far as this executive inquiry is concerned,
Lordship.
there also the findings are that ultimately so in short, Mr. Chaudhary, what is your suggestion about the prayer that is prayed for? Because we will have to deal with it when we dispose of it.
Lordship, I would submit, Lordship, of course, since some persons have been killed. Yes, Lordship, award some compensation. But so far as the other prayers are concerned, regarding prosecution, arrest, Lordship, it comes out from the inquiry itself. These were not innocent people, Lordship.
No, that is what we are showing it to you.
Yes, these are not innocent people, Lordship. Lordship will not go into that part.
yes, I agree.
That Lordship will not go into that part, but since somebody has been killed, Lordship will examine on the quantum part.
Income also has to
It's
be,
quite a old matter, Lordship. This
See.
time it should be laid to rest.
no, it will be laid to rest today only.
Lordship.
We are only asking for what?
Yes, it's, yes.
You take out that statement. It's reported. See, now it is reported. So it is in Manu Patra, now it is in GLR. Take out equivalent in GLR. Mr. Chaudhary, the purpose of asking Mr. Counsel was that if we have to deal with that part of the prayer, then we will have to refer to the whole pleadings in the petition. If we can record is that he is satisfied with this, then the matter ends there, then we.
He says.
Yes, I'm satisfied. That is the reason, otherwise.
Yes.
Read petition, civil number. Will dispose it of, will dictate the judgment in the open court. So the matter can be put into after 7 years. You have no other matter, it is better we complete it.
Yes.
You can take seat, both of you. If anything is there, you can
Yes.
suggest while I am dictating.
Flush.
This petition civil number 4425/2015. By way of this petition under Article 226 of the Constitution of India, the petitioner has prayed for the following relief. Based upon the factual matter is stated more particularly in paragraph number 3 and 4 of the 3, 4 and 3 to 10. It was contended that in breach of the guidelines issued by Honorable Apex Court in the case of D.K. Basu versus State of West Bengal, reported in 1997, 1 SCC page 416. The respondent authorities and more particularly the army officials have acted in such a manner resulting into loss of life in an illegal manner. It was contended that an inquiry should be made into the unnatural death of the deceased family members of the petitioner. In response to the notice issued by this court, the respondent authorities have filed affidavit and have also brought on record the copy of the ministerial inquiry held into the incident complained of. The inquiry also shows that the cause of death of all the disease was due to hemorrhage and shock as a result of injuries sustained caused by firearms, which were anti-mortem and homicidal in nature. The further affidavit filed by the respondent authority on 10 February 2016 also indicates that an FIR was lodged with Runikata Police Station, being FIR number 59 of 2014, on 208/2014 for alleged offences under section 120P, 121, 121A, 122, 5, 353, 307 of IP code, read with section 25, 1A and 27(2) of the Arms Act, read with section 4 of ES Act and read with section 15/16 of UAP Act. Such FIR was lodged by one Major P.N. Singh Kumar. The record indicates that large ammunition was recovered and the victims were wanted in some offences as enumerated in the state affidavit, and on each of the victims, cash rewards were also declared by the government. Mr. Chaudhary, which is the affidavit that you are referring to?
Lordship is the affidavit filed in March 2020, where I have won by Rahul Srivastava.
It is also pertinent to note that the central government, through the officer of commandant of Pike Dhariwal Rifle, Mantri Rahul Srivastava has filed an affidavit on 29th of July 2020, wherein it is contended that there is no violation of human rights in the joint operation conducted by Army and Police on 20th of August 2014, and the ministerial inquiry carried out immediately thereafter also indicates that the persons involved in the firing were known terrorists having connection with outfit so and so, page 50 के ऊपर चलेगा. A further affidavit is also filed by one Sri Joten Musarai on behalf of the petitioner number 3, denying the said contention. The record indicates that an additional affidavit has been filed by respondent number 3, wherein it is contended that the Runikanta police station case number 59 of 2014 was investigated by an independent investigation officer, and the case was supervised by the APS, Deputy Superintendent of Police Headquarters, Iran, and FR has been submitted. The report further indicates that a fact-finding inquiry was also conducted, wherein threadbare discussion of the incident which occurred has been made based upon the statements of the various witnesses. Mr. T. Temru, counsel appearing for the petitioner, candidly submits that as far as the inquiry is concerned, and furthermore, the inquiry made pursuant to the offense registered as FIR number 59 of 2014 is done in proper manner and the petitioner is satisfied with the said inquiry. Having considered the various affidavits as discussed here in above, as well as the report of the inquiry, which is forming part of the record, it was conducted by District and Sessions Judge Chirang, which is placed on record by the report dated 25 July 2019. This court the record satisfaction of the inquiry made by the authority. In totality of facts, the fact remains that the inquiry has been properly made and no further inquiry is necessary, which is also admitted by Mr. T. Fury, learned counsel appearing for the petition. And as such, the main prayer straightforward in the petition, therefore, gets satisfied. However, as straightforward in the petition, considering the provisions of considering the right of the petition under Article 21 of the Constitution of India, and following the decision of this court reported in so and so, the fact remains that the persons killed, five persons were killed in the encounter in the joint operation carried out by Army and Assam Police. And therefore, it would be appropriate to award adequate monetary compensation. It is also a matter of fact that the persons killed were wanted in offences which are serious in nature, and it is also alleged that they were members of so and so. It is also a matter of record that sophisticated weapons were also recovered. However, keeping in mind the fact that they lost their life at the hands of army personnel in particular, keeping in mind the ratio laid down by apex court in this court in the case of Ponto Varisa and others Supra, wherein this honorable court has taken into consideration the patina of judgment of the honorable apex court and has awarded adequate monetary compensation. Paragraph. In the peculiar facts and circumstances, and considering the credentials which are on record, which is not denied by, which is not controverted as such, we deem it fit to quantify the monetary compensation at rupees 2 lakh for each of the persons killed. As the 5 persons have been killed in the encounter, the respondent authority shall pay total sum of rupees 10 lakh, that is rupees 2 lakh each, which in opinion of this court would subserve the interest of justice and in same would be in furtherance with the provisions of Article 21 of the Constitution. The aforesaid direction we deem it fit to close the proceedings. Notice this that
Lordship has, if your Lordship, Lordship,
pay and recover like MSAT.
Lordship is fixing a time limit for
Will provide within 4 months from the date of the receipt of the certified copy of this order.
Lordship.